Good morning, all of you. In today's scenario, we are going to learn the basics of criminal code practice. As we already done the civil part, so in the civil part, we gone through the important thing, that is the zero stage for the civil cases, in which we learn for the civil case, zero stage will be there. That means any dispute or the infringement of rights should be there. Then and then only civil case will be lies in the court of law. Otherwise, there is no any particular fact or the issues that help any client to institute the suit in the court of law, basically in the civil cases. In the next part, in today's scenario, we are going to learn the basics of criminal code practice. So likewise in the civil cases, we gone through the infringement of right or the dispute. Likewise in the criminal cases, the zero stage in these criminal cases is about, we can say it as a crime. If I want to register the complaint before the police station or before the court or the magistrate, there should be some kind of dispute relating to the crime, or we can say it as simply crime should be there. Otherwise, no case will be registered as a criminal case. So this will be the zero stage for the criminal point of view whenever we have to learn for the same. So I'm just sharing you the screen. So we'll continue for the further parts regarding the same. Okay. Okay, so these are the important part. We can say it as a zero stage. Zero stage is about the crime or the offense should be there whenever we have to go through the criminal scenario. But along with the criminal scenario, we should have to remember हमें इस सिचुएशन में और भी कुछ चीज़ों को इकट्ठा करना होगा और उसी के बेस पर हम जीरो स्टेज से आगे बढ़ने की कोशिश करेंगे. Basically for the criminal part of view, I think there is some change of setting. तो हर दफ़ा कोई ज्वाइन हो रहा है तो इशू हो रहा है, उसमें शायद कुछ नोटिफिकेशन नहीं आ रहा है. तो जीरो स्टेज का जो भी पार्ट है, जीरो स्टेज मीन्स देयर शुड बी सम काइंड ऑफ crime or the offense, but along with the same scenario, we should have to remember the distribution or the types of crime should be there. Then and then only we can link all the zero stages together with the crime, and all these types of crime are going to help us what kind of case it is, whether it is serious in nature or the non-serious, whether it is cognizable and non-cognizable, whether it is compoundable or non-compoundable, whether it is bailable or non-bailable. This kind of things will be there. So these are the important part that we should have to learn regarding the same. So in this particular things, wait a moment, let me join all the student together, वरना ये ऐसे ही चलता रहेगा. अच्छा, am I audible to you now? आवाज़ आ रही है मेरी? So we'll continue for the same. Am I audible to you? Okay, thank you. Okay, तो in this particular scenario what we have to do कि भाई जो भी कोई स्टेज होगी इसमें खास करके जिसमें हमने जो पहला वाला पॉइंट देखा है जिसे हम कह रहे हैं जीरो स्टेज, दैट मीन्स कोई क्राइम होना चाहिए उस केस में, कोई ऑफेंस होना चाहिए, उसी सिचुएशन में उस केस को रजिस्टर्ड किया जाएगा या फिर रजिस्टर्ड होने के बाद उस केस के रिलेटेड प्रोसीजर वगैरह जो भी हो सकती है वो कोर्ट में चल सकती है। इस सेम सिनेरियो में जो भी क्राइम है उस क्राइम के टाइप्स ऑफ ऑफेंसेस और टाइप्स ऑफ क्राइम भी हमें देखना पड़ेगा, उसके लिहाज से हमें थोड़ी सी हेल्प हो सकती है। तो व्हाट काइंड ऑफ हेल्प इट इज़ अ काइंड ऑफ हेल्प इन विच वी हैव टू डिस्ट्रीब्यूट द टाइप्स ऑफ क्राइम and along with the same scenario we have to distribute all these types of crime in the few things. That means whatever the kind of crime, whether it is serious in nature or non-serious, whether it is cognizable in nature and non-cognizable, all these parts we should have to remember for the same point of view. Then after for the next part we also have to learn whether that particular part or the case is bailable or non-bailable, and the last and fourth part is regarding whether that particular case is compoundable or non-compoundable. So this is the one of the important part we should have to remember in this particular thing, and we have to explain all the things together, so it would be help us the distribution of crime according to criminal cases. So in the journey of criminal things we should have to remember what kind of crime it is serious in nature or non-serious. So basically serious in nature and non-serious in nature, that means in many of the dictionaries or the books available on the internet or surrounding us, it is saying that whatever the kind of crime in which the punishment of that particular crime is more than 3 years or the 2 years, that particular crime we can say it as a non-serious in nature. Means there is no any death penalty or the life imprisonment or the hard kind of fine or the imprisonment, rigorous imprisonment we can say it, or different kind of offenses in which the particular court having a power or the particular offense is regarding is some serious in nature, means if that kind of offense or the crime will be happened over there, so court can punish more than 3 years of imprisonment or some kind of fine. So such a kind of differentiation in between serious in nature and non-serious, means in serious in nature whatever the punishment will be there, it is more serious or the more than 3 years, or in the non-serious the punishment is about less than 2 or 3 years. So this is the two kind of definitions are there which are available in the market. Particularly are saying serious means offenses or the crimes in which punishment is more than 2 or 3 years, and in non-serious punishment is less than 2 or 3 years. So this is the first part that we should have to remember. In the next part we have to gone through the cognizable and non-cognizable things, bailable and non-bailable in the third part, and in the fourth part compoundable and non-compoundable part. So for the same purpose we just have to go through the chart for the same. Okay, you can take the screenshot if you want. So this will be the first part for the point number 2 regarding the cognizable and non-cognizable offense. So cognizable and non-cognizable offense means it's depending on the what kind of situations are available in the particular suits, not particular suits but the complaint. If any complaint will be registered before the police station and police station authority having such a kind of power to investigate the matter without court's permission, to arrest the person without court permission. So in this particular scenario, we can say it as a cognizable offense, means that offense is serious in nature, and that is why we are giving the authority to police wala, so they can arrest any person without warrant and they can start the investigation in that particular case without permission of the magistrate. So this kind of things are there in the criminal scenario, basically for the cognizable offense. Cognizable offense are serious in nature, and that is why in this particular scenario, if any person who want to register the complaint, he have to register the complaints on the basis of FIR, first information report, because the crime or the offense is in serious in nature. That is fine. So whenever we have to remember, if any FIR will be registered as a complaint in the form of written things or in the form of oral things, that particular crime or the offense is registered via FIR, so that particular offense is cognizable in nature. That means police wala can take the cognizance of that particular offense without taking the prior permission from the magistrate court or the any other court. So in which many serious kind of offenses are there. That means some few examples are there like rape, murder, dowry death, etc. And just opposite to the same, non-cognizable offense means they are comparatively to the cognizable offense, they are non-serious in nature. Police wala should have to take the prior permission from the court for the arrest of any person, even the accused or the witness or the any kind of person in this particular case. Police wala have to take the permission for the investigation in that particular case from the court, and without court's permission they can't do anything. And for the registering of complaint in the criminal scenario, in the non-cognizable offense, it is done on the basis of non-cognizable report, not via FIR. So these are the two kind of difference that we can go through for the same. So cognizable offense means serious in nature, non-cognizable means non-serious in nature. We gone through the definition. Serious in nature and non-serious in nature means if 2 years or more than 2 years of punishment will be there, are the serious in nature, or the less than punishment will be there, then that we can say it as a non-serious in nature. In the cognizable offense, without warrant police can arrest or investigate. In cognizable offense, without permission of the court, police can investigate or arrest the person, and differ or the opposite in the non-cognizable offense. Likewise, person is not going to arrest or the no investigation will be begin or the start in non-cognizable offense. In cognizable offense, FIR should be there to register the complaint, and in non-cognizable offense, NCR, that we can say it as a non-cognizable report. It is one of the part to register the complaint which are non-cognizable offense. In simple words, we can say it as a NC also. So these are the important part. And for example, for the non-cognizable offense. Many times it is about the simple hurt or the assault or the defamation. So all these parts are there in the form of non-cognizable offense. The next part for the types of offense means it is talking about the what kind of offense it is, whether it is bailable or whether it is non-bailable. So bailable offense and non-bailable offense means in the bailable offense give the bail to any person who is arrested or who are arrested in that particular offense, having a right to get the bail from the court. It is their right, and there is no any restriction or the burden on the court to not allow the bail, because under the Constitution of India, if any person who is arrested over there, he should have a right to life, free of right to life. So that is why that person should be live his life on freely manner without arrest and all. So in bailable offense, it is regarding if any person is arrested over there, so in the court of law that person should grant the bail, and in this particular scenario that person having a right to bail. And many times we can say it as a in the bailable offense, many of the non-serious in nature of crimes are there. That is why we can easily allow the bail to the accused or the offender, and the same part as a opponent side. Likewise, in the non-bailable offense, they are serious in nature, more serious in nature offenses are there. There is no such a kind of right of any accused or the offender to get the bail, but with due permission of the court or the due procedure of the law, any person can enjoy the bail, but court is going to cross check or enforcing few kind of conditions on that particular party or the person to get the bail. And as we already say, non-bailable offense are the more serious in nature. So for example, in this particular scenario, rape is there, murder is there, dowry death is there, kidnapping is there, attempting to murder is there, means all are the serious in nature. Means in all the scenario, the punishment to any person is about 3 years or 2 years or more than that. So such a kind of things are there. So these are the kind of difference on the basis of bail. If any person is enjoying the bail, means that is the bailable offense, and in this particular bailable offense, court can easily allow that person bail as a right. And in non-bailable offense, bail is not a right but due procedure of the law, that person should enjoy the bail, but court is going to cross check all this scenario whether the validity count is there to grant the bail. And the next part is regarding whether any conditions are enforced on that particular person or the accused to give him bail. So these are the kind of things in which we can say it as a bailable offense or the non-bailable offense. Last and the next part regarding the types of offense is regarding compoundable offense and non-compoundable offense. According to the section 320 of CRPC, Compoundable offense means such a kind of offense in which the person accused or the person who is the complainant or the victim or the accused may enter into such a kind of conversation in which accused and victim, whatever the kind of complaint it is, whether it is non-cognizable in nature or cognizable in nature, if victim is going to compromise in this particular scenario, many times permission of the court is required by the victim, in which they are going to do the compromise even though there is some kind of offenses are there against that opponent party or the victim or the accused. Means whatever the case is registered in the court of law as a criminal complaint, if any victim allow or the grant for the compromise or the settlement or the amicable settlement, then the case or the complaint or the particular head of charge against the accused might be vanished or diminished because of victim wants to compromise in this particular suit, and that is why many non-serious kind of offense, they are not that much often serious in nature. In this particular kind of crime, court is going to allow by the virtue of the permission of the victim, any persons who is the opponent party or the accused is granted to discharge from that particular offenses. But many times this scenario is depending on the permission of victim or even on the permission of victim, but there should be a grant from the court. So this is the first part that we can say it as a compoundable offense. And just opposite to that, whatever the part that are available in section 320, and apart from the section 320, whatever the kind of offenses, they are non-compoundable in nature, means no such a kind of compromise are there in that particular suit, means they are serious in nature offenses like murder or the kidnapping. So that is why court is not going to allow, or even victim is not permitted to grant the compromise to the opponent party or the accused. So these are the simple kind of scenario in which we should have to learn. So whatever the kind of scenario is there regarding the types of offense, regarding the particular types of offense on the basis of bail, cognizable offense or the compoundable offense or the serious in nature, non-serious in nature, we can say it as the procedure of particular offense or the criminal procedure will be done. It totally differs with the type of offenses. In the next part of that, we should have to learn the first schedule of CRPC. Screen is visible to you, so you can inform me. Okay. So this is the CRPC part. In this particular CRPC part, we have to learn the first schedule. And what first schedule is saying? First schedule is helping us or the any advocate to allow them to differentiate in between the offenses or the crime according to the first schedule. We can learn the few important parts. We can say it as a okay. This is the first schedule. First schedule is saying some classification of offenses on the basis of some columns are there. So whatever the kind of offenses which are available in the IPC, Indian Penal Code, are differentiate or are included in the first schedule of offense, and they are giving such a kind of information whether that particular offense are under particular section, or the definition of particular section, or the punishment in that particular section, or the offense or the crime of IPC, whether that offense or the section of IPC is bailable or non-bailable, whether that section of IPC is cognizable or non-cognizable, and under which code that matter is going to triable. So all these parts are there regarding the first schedule. So if we gone through the scenario, the first thing is regarding the section, second is offense, means definition of offense, third is regarding the punishment, fourth is regarding the cognizable offense or the non-cognizable, fifth is regarding the bailable and non-bailable, and last or sixth thing is under which code the matter is going to triable. So this is the important part. As advocate we should have to remember, and along with the same part you will get the proper knowledge under which code the matter is going to triable, along with in which code the matter in under that particular matter you are going to apply for the bail as a lower court. So these are the particular scenario. If we gone through one by one section, you can realize many things are there. Likewise, if we gone through the section 121 of IPC, it is saying that the definition of the particular section is if any person is going to waging or attempting the war or abating the waging of war against the government of India, in that particular scenario, that person is having a punishment under that particular section 121 as a death penalty or the life imprisonment or the fine, and that kind of offense is cognizable in nature. You won't have a right to get the bails, means that is a non-bailable offense, and in this particular scenario the trial will be done in the court of session. That means as a cognizable in offense, FIR is going to registered. Court have a right to start the investigation without court's permission. Court have a right to arrest any person without permission of the court, and all these kind of offense are serious in nature, because in this particular offense the punishment is more than 2 or 3 years. So this is the kind of part. And the next thing is regarding the non-bailable offense, means it is the serious in nature offense, and that is why any person is not having a right to get the bail as a right, but court can give the bail as a with some condition or with following the due permission of the whatever procedure of the law. So all these things are there, but it totally depending on what court thinks fit so. And the last part is regarding the if this matter is proceed in the court of law, the trial should be done in the session court. So likewise all the scenario are there. After some time we are going to learn the types of jurisdiction in the criminal court also, but before that we just have to gone through the same scenario, and this will be the important chart to learn how the things are going to done. Next part is regarding whatever the ditto means. Ditto means whatever they written over there about it is just repeating over there, and that is why we are just informing or mentioning the ditto over there. So in this particular scenario, collecting arms under section 122 with intention for the waging war against the government of India, in which ditto means whatever the scenario written about to it means cognizable offense, that should be here. Non-bailable offense, that should be here. Court of session, under which court the matter will be triable, ditto is there, means in the court of session that matter is going to be triable. So this will be the scenario. So this is the important part for the first schedule, and if you are going to learn how the first schedule is going to read, then you can easily remember how the things are going to turn in the court of law. Means only by following the first schedule of CRPC you can remember how the things are going to done in the criminal cases. If any particular section is available in your FIR or the NCR, so suppose one of the section is available in the FIR regarding section 122A of IPC. What is the particular definition of section? Shashidhar ji, what is the particular section or the definition of particular section 124A according to any FIR? Kavita ji, Kiran ji, what is the definition of particular section? Section 124A. You just have to read it down. I already shared the screen to you. Rajat ji, Shivraj ji, Sumit ji, Hema Kumar ji, am I audible to you? आवाज आ रही है मेरी? जी, शिवराज जी, can you please read it for us? What is this section 124A? जी, क्या है 124A? What is the definition? It is regarding the sedition, okay? Column number 2 is saying at the particular definition of the offenses. Then after punishment in the sedition charge, the punishment is regarding the imprisonment of life and fine, or imprisonment for 3 years and fine, or fine only. And it is cognizable in nature, means FIR should be registered. Police have a right to arrest any person without warrant. They can start the investigation immediately without prior permission from the court. It is non-bailable, means serious in nature offense. There is no any right of to get the bail, but court can permit the bail, allow for the bail with due permission of the procedure of the law. Or in this particular suit, not suit, but in the crime or the complaint, the trial should be done in court of session. So these are the particular things. If we gone through the next part, suppose section 133 is there. Who is gonna read for us 133? जी 133 कौन पढ़ पाएगा? शशिधर जी, सुमित जी, जस्ट सामने लिखा हुआ है वही पढ़ना है और कुछ भी नहीं है इसमें. वी ऑलरेडी हाईलाइट द सेम पार्ट. जी किरण जी, ओके. कॉग्निजिबल का डिफाइन करोगे? ओके. FIR should be registered in the same part and many offenses are serious in nature. और नॉन बेलेबल का मतलब ओके मीन्स ड्यू प्रोसीजर ऑफ लॉ होगा. प्रोसीजर ऑफ लॉ में अगर लगता है कि बेल मिलनी चाहिए या फिर नहीं मिलनी चाहिए तो अकॉर्डिंगली बेल मिलेगी या फिर नहीं भी मिल सकती, बट राइट नहीं है किसी भी पर्सन का. नेक्स्ट पार्ट इज कोर्ट ऑफ सेशन मीन्स अंडर विच कोर्ट दैट मैटर इज गोइंग टू ट्रायबल. तो दिस इज द वन ऑफ द पार्ट इन विच वी कैन रिमेंबर if any FIR is available in front of us and if we are gonna read the FIR then we can remember that कि भाई इस तरीके का कोई FIR आता है, उसमें कोई पर्टिकुलर सेक्शन होता है, तो we can go through the same, ये जो कुछ भी सिनेरियो उसके अकॉर्डिंग. तो if we'll take one example, समझ के चलिए. ओके ओके दिस इज़ वन ऑफ द FIR. समझ के चलिए उस FIR में ये कुछ सेक्शन वहाँ पे लिखे हुए हैं. भारतीय दंड संहिता जो भी है, इंडियन पिनल कोड, IPC. अगर आपको हिंदी नहीं पढ़ना आता है तो बस इस सेक्शन जो है साइड में लिखे हो उस पर गौर कीजिएगा. व्हाट सेक्शंस आर सेइंग कि भाई IPC का जो भी सेक्शन है वो क्या है. IPC का सेक्शन 294, IPC का सेक्शन 506, IPC का सेक्शन 507, IPC का सेक्शन 34. Whenever IPC का section 34 will be there, you should have to remember कि भाई it is regarding the criminal intention of more than one persons, which is common intention of both the parties or the more than two persons, or the common intention or the malified intention to do such a kind of conspiracy or the crime. Means whenever you are going to read section 34 in any FIR, you should have to keep one thing in your mind: there are more than two persons are there, not a single person. So this is the first part. Then after section 294, 506, 507, you have to read and go it through the first schedule. Means if we have to read it over there according to the first schedule, we can easily remember the few things. Means if we have to read it down that particular FIR, we will go through the section 294, right? I'm just coding it down. Okay, this is the 294. What it is saying? It is saying offense song, imprisonment for 3 years, not 3 years, 3 months, or fine, or both. And if ditto is written over there, means whatever the scenario of above part is, that is it over there, means it is cognizable in nature. That means some serious kind of offense is there. FIR should be registered, or whatever the police wala can start with the investigation without permission of the court, or arrest any person without permission of the court. Then in the next part, if ditto is there, again we have to move the cursor. It is bailable in offense. I mean, in this particular type of offense, bail is a right of that particular accused or the offender. And the last part, that matter is triable before the any magistrate, under which the court is going to competent over there. So likewise we can read it as a particular section. Means if section 294 is there in any FIR, we can open the first schedule of CRPC and we have to gone through the same scenario. The next section was regarding, what was the next section? 506, right? 506 and 507. So again we have to move it towards the 506 and 507. Okay, so 506 is regarding the criminal intimidation having an imprisonment for 2 years or fine or both. It is non-cognizable in nature, bailable in nature, and ditto means it is triable before any magistrate. So such a kind of things are there in the criminal intimidation. If any trait or the cause of death or the grievous hurt is happened over there, in which imprisonment for 7 years or the fine or the both is as a punishment will be there, it should be non-cognizable in nature, bailable in nature, and triable by any magistrate of first class. So if non-cognizable means non-serious, bailable means easily get the bail as a right, and triable by any magistrate. So this will be the second part of section 506. Next part is regarding the section 507, criminal intimidation by anonymous communication or having taken precautions to conceal fiance the threat comes. Then after, the next part is regarding the imprisonment for 2 years in addition to the punishment under above section. They are talking about the 506 here. It is non-cognizable in nature, it is bailable in nature, and triable by first class of magistrate or the any magistrate, depending on the scenario. So likewise you have to read the FIR, whatever the sections are there. If any FIR, as we already mentioned over there, in this section 294, it was in cognizable offense. Means whenever any cognizable offense will be there, then and then only FIR will be registered. Otherwise, non-cognizable report will be registered. And because of in this particular FIR, section 294 was there, it is saying that the nature of that particular offense is cognizable in nature, and that is why FIR is registered. And if any of particular section is of cognizable in nature and remaining section is of non-cognizable in nature, even though in this particular scenario, in this particular complaint, it should be registered via FIR only. But if any all the non-cognizable offense are there, that means that particular offense or the complaint is registered on the basis of non-cognizable report, not on the basis of FIR. So these are the particular things. Because of the sections, all the sections are non-cognizable, case will be registered as a non-cognizable report. But out of some sections, even single section, it is of cognizable in nature. So in this particular scenario, cognizable report means FIR should be registered. So this is the scenario of first schedule. Apart from the same, if we gone through the section 320, don't worry, we are going to share the file to you after the session in the group. You can go through the same. Okay. According to the section 320, it is giving us example regarding the particular sections in which we can easily compromise with the victim and the case will be dismissed over there. Although whatever the charges are there, they are vanishing from the same, or you will get the discharge from that particular section if such a kind of section that are available in the first part of section 120 320. So they are giving some kind of points over there. If any voluntarily causing hurt under section 323 is there, then the person to whom the hurt is caused, if that going to compromise with you, then whatever this discharge is lies over there, court can discharge you from that particular section. So likewise, section 320 is giving us information regarding some of the section in which victim can directly compromise with the accused, or some of the sections are regarding the, even though any person or the victim is going to permit the opponent party or the accused or the offender for the compromise, but court's permission should be there, and according to the court's permission only that person are discharged from particular section. So likewise, you have to go through whenever any FIR will be there, you should have to remember the first schedule and section 320 of CRPC, and these are giving the information regarding the what kind of offense it is, whether it is triable by which court, whether it is bailable or non-bailable, whether it is cognizable and non-cognizable. So these are the important part we shall to learn in today's scenario. Tomorrow we will continue for the next part. I am going to share few FIR in the group after the session. You just have to remember, just have to learn some sections according to the first schedule and according to the section 320 of CRPC, and you have to note it down, whether it is cognizable in nature, non-cognizable, whether it is bailable, non-bailable, under which court that matter is triable, all such a kind of things are there. So that's it for the today's scenario. Tomorrow we have to finish the criminal part and we have to continue tomorrow for the criminal part. Okay, if you have any question, you can ask me within 2 or 3 minutes. Otherwise we are just winding up now, and tomorrow we have to resume with the criminal part. Okay, कोई सवाल है आपका तो पूछ सकते हो आप जी, किसी का कोई सवाल है? I have to visit the court early, so I have to move the court. That is why we are not taking the lengthy session today. So we'll continue the session. Okay, tomorrow. Okay, have a nice day. If you're not having any questions, so we'll continue the session tomorrow. Okay, have a nice day.